Okay, so yesterday, um, talking about the judicial branch, we left off on this. The Supreme Court's the highest court in the nation. All its decisions are final, and that typically, it's only going to hear 150 of thousands of cases, and most of those cases are from appellate jurisdiction. So we're going to start off today talking a little bit about what that means. So, appellate jurisdiction is just the right for a court to review a case that's already been decided. So, typically these cases are starting in lower courts. So if you lose a case in a lower court, you can appeal it to a higher court. And there are steps before it gets to the Supreme Court. We're going to look at the pathway in a second. But essentially, it's going to go to a court of appeals. And then after the court of appeals, if you don't like your verdict, you can appeal it to the Supreme Court. But like we've said in the past, it is very unlikely that the Supreme Court is going to hear your case. And if you need to pause to write stuff down anytime, feel free to do that. But since it's a video, I'm just going to keep rolling. So this is a little more about how the Supreme Court works. It is in session from October to June and July each year, so it's not the whole year. It's a set, kind of season of the year almost. And each month is going to follow a certain pattern. The first 2 weeks of the month, so kind of split the month in half, the court hears cases, makes announcements, and discusses current cases. So this is where they're actually hearing the cases. And there's not a what's the word I'm looking for here? There's not a jury. That's what I was trying to think of. In Supreme Court cases, it's the 9 justices themselves hearing the case, making decisions, asking questions, then coming up with the verdict. And that's what they do in the second 2 weeks. The second 2 weeks, they make their decisions and they write opinions about those decisions. We're going to talk more about opinions in just a second. And they're also deciding on what new cases to hear and researching other cases. So that's kind of split up. 2 weeks is actively looking at or actively doing the cases. 2 weeks of kind of research, writing, stuff like that. And they're not working alone. They've got plenty of aides and people there helping them do all this stuff. So it's not just 9 people, doing all of this on their own. Okay, so if they have the power, they have appellate jurisdiction. How do they figure out which cases they want to choose? So this is how they do it. 4 of the 9 have to agree. So you don't have to have a majority to hear the case, but 4 of the 9 Supreme Court justices have to agree to hear a case. And they've got other people researching these cases too. It's not just them, like I said. Now, typically, they're only going to hear certain kinds of cases because they want their cases have a focus, and it's to kind of make our legal system clear. It's not just to help the people in the cases, although that happens. It's not just to decide that; it's to figure out what we're going to do going forward. So they're only going to hear cases that involve constitutional issues. They're also going to hear cases that involve equal protection under the law, which is the 14th Amendment. We are going to talk more about the 14th Amendment going forward, but just so you understand why they do it, the 14th Amendment is, I would say, for you, a private citizen in the U.S., one of the more important amendments to the Constitution. So I think we all know about the Bill of Rights, like some of the Bill of Rights, for example, the freedom of speech. We all know that that's something we have. You can't get in trouble with the government for saying whatever it is you want to say, as long as what you're saying isn't going to cause panic or hurt people. But when the Bill of Rights is initially introduced, it's only protecting you from the federal government for that. It's this document applies to the federal government. It's only protecting you from that. The 14th Amendment is kind of a way to incorporate those protections to everyone. So the 14th Amendment is why, your Bill of Rights protections apply to the state and to local government as well. We're going to get more into this. It's okay if you don't understand it right now, but we will definitely look at more on this in the future. The Supreme Court is also going to look at cases that involve civil liberties. So this is kind of their focus. Outside of this, they're not hearing many cases. And usually, remember, they're just hearing these appellate cases. It's coming from lower courts. Very few cases start in the Supreme Court. To get a petition to the Supreme Court, you have to write a writ of certiorari, I don't care if you know that term, but that's what the writ is called with the Supreme Court. All right, next on our list. All right, this one is a little longer. It's got a lot of vocabulary words, so you want to make sure that you have these written down. So 6 justices have to be present to make a decision. There are 9 justices total. 6 of them have to be in the room together in order to make a decision, and they can make one of these 3 decisions. They can choose to uphold a verdict. So say a lower court made a decision, it gets appealed to the Supreme Court. If they uphold the verdict, it means they agree with the lower court. So the decision stays the same. They can overturn a prior ruling. So they can say, the lower court made the wrong decision. We're overturning their decision. They can also remand a case back to a lower court. Now, why would they do this? Essentially, they would do this because of precedent. That's Precedent. Precedent. You hear all the time right now that we're in unprecedented times. That means it's something that has never happened before. So precedent is something that has happened in the past. And when it comes to the courts, precedent is important because future decisions rely on what has happened in the past. For example, this all kind of comes from English common law, which we've talked about before. But like, say for example, someone steals a loaf of bread, and a judge somewhere back in time decides, the penalty for this should be that you get your hand cut off for stealing this loaf of bread. That's not necessarily written down. It's not a law, but it's what the judge decided to do. So in future cases, when other judges are deciding similar cases, they're probably also going to be like, oh, you stole a loaf of bread in the past. The penalty for this has been, cutting off your hand. So we're going to cut off your hand. That's what precedent is. It's looking to past decisions to guide what to do in the future. And when the Supreme Court sets down a precedent, it's going to be very difficult for lower courts to disagree with it because they're not as powerful as the Supreme Court. So everyone is looking to the Supreme Court's precedent. So if the Supreme Court isn't ready to set a precedent on a case, that might be a reason for them to remand it down to a lower court so that they don't have to set a precedent on whatever it was that they might set a precedent on for that case. Once the decisions have been made, at least one justice is going to write an opinion. You could have a unanimous verdict, in which case there would be no dissenting opinion, but you're always going to have a majority opinion. That's where one justice, it doesn't have to be any particular one, it's just one that's on the majority side, writes essentially an explanation of why they came to the decision that they came to. You could also have a concurrent opinion. This is agreeing with the majority opinion, but it might be agreeing, maybe they came to the decision for a slightly different reason. You could also have a dissenting opinion, which is when, the justices who were in the minority write the opinion about why they disagree with the opinion that was given in the case. So that's it. Make sure you have these words written down. These are important vocabulary terms. Now, a couple more things before I finish. This is how the court system is set up. So this is the kind of the pyramid that the Supreme Court is on top of. So if you're talking about federal courts in the U.S., that's kind of at the bottom. These trial courts, there are 94 judicial districts. So if you're in a federal court case, maybe if you've committed a federal crime, this is where your case would start. If you didn't like your verdict, you could appeal it to an appellate court, which would be kind of the middle part of the pyramid. There are only 12 regional circuit courts of appeals. So depending on where you live or where the crime took place, you would go to one of those 12 regional courts. And then after you would appeal through that, you jump up to the Supreme Court. So that's how that would work. This is how most cases get to the Supreme Court. Most of them go through the federal court system. However, you could also go through the state court system. And most cases in the U.S., an overwhelming amount of them, are happening at the state level. You commit petty theft, you're going to be in the state trial court. If you commit, murder, that's going to be a crime against the state. It's going to start there. So most cases in the United States are happening here, but less of them make their way to the Supreme Court. So you might start in the state trial court, you might appeal to a state appellate court, and then maybe you can get your case heard in the state Supreme Court, which is the highest court in your particular state. But then, if you want to appeal from there, you'd have to appeal to the U.S. Supreme Court. So most cases that end up in the Supreme Court start in the federal court system. Some start in state courts, and only 5% are cases that start in the Supreme Court. So that's it for the notes today. We're going to finish these up tomorrow, and then we're going to look at some kind of big Supreme Court cases. Let me know if you have any questions. Otherwise, have a good day.